Yes. Now, under the criminal law, we see the concept of discharge. Now, discharge, we understand in the earlier CRPC, that is Criminal Procedure Code, and now we are understanding in the same manner in the Bharatiya Nagrik Suraksha Sanhita, that is BNSS. So, discharge is basically a very stage which actually occurs before the trial starts, and that is based on a very prima facie initial assessment of evidence and documents. And at this stage, judge have a discretion that they can discharge the accused if he believes that there is no any concrete evidence to proceed with the trial, or he firmly understand that the accused is maliciously charged with that particular offense. And so discharge is not like a final judgment, but it is something which is in a very premature stage of the that particular judicial proceeding. If the evidences they are not sufficient to prove that the accused might have committed that offense, then the honorable court or the judge in its discretion can release that person from any liability under that particular offense. Of course, this is not the very judgment. In future, if suppose any new evidence, new fact found in that particular case, then the case can be reopened and again the charge can be imposed on that particular accused. Now, in the criminal law, we understand that discharge basically they are found in the three different cases, or three different codes. Say discharge under section 227 in the CRPC, we understand when the trial before a court of session is conducting, then we understand discharge in a cases where trial of warrant cases by magistrate instituted on a police report. In that case also, in section 239, we understand the provision of discharge. Then trial of warrant cases by magistrate otherwise than instituted on police report, that under the section 245 of the CRPC, the provision of discharge we understand. So in three cases there is a provision of discharge we understand, and the discharge is something which is different from the acquittal. When on the basis of evidence and documents and all that thing, when the court conclusively decides that, gives the judgment that the person is not entitled for any punishment and there is no any commission of offense, or the offense is not proved against that person, then we can say the person is acquitted in the case. Lekin as I said initially, discharge is something different from that. Now when we read section 227, of CRPC, it says that if upon a consideration of the record of the case and the documents submitted therewith, and after hearing the submission of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for doing so. So in this section it is clearly mentioned that on consideration of the record of the case and on consideration of documents submitted in that particular case, and at the same time after hearing the submission of the accused and the prosecution in regards with that matter, if judge considers that there is no any sufficient ground for proceeding against that accused, then he shall discharge the accused and he shall record the reasons for doing so. Now in this section 227, we have to understand that judge has to use his discretion while using the power of this particular discharge under section 227 of the Criminal Procedure Code. So इसमें judge has to see that he is making out a prima facie case against the accused. If he is understanding on the basis of a very facts and circumstances that there is no any merit in the case, or there is no any circumstances which primarily make out the offense, which primarily indicates that the accused might have committed that particular offense, then the judge under section 227 can exercise his power and discharge that particular accused. Now in this section 227, judge supposed to exercise the power in a manner that he is evaluating the facts at the very face value. He has to see that whatever facts and circumstances emerge from that particular transaction, they basically and in the very prima facie discloses the existence of all the ingredients which constitute that alleged offense. And if he understands that on the very face value we can reach out to the conclusion that the accused might have committed that offense, then he can proceed with the framing of charge against that accused. But if he have a very doubt in regards with the facts and circumstances, and he is having a very suspicion in the mind that the charges they are groundless, then in such situation he can rightly discharge the accused. Now in the same manner, section 239 provides for the another case, another trial, and that is a trial before the court of session, that is a trial of a warrant cases by magistrate instituted on police report. And in that particular section 239, same like section 227, we understand that if upon the considering the police report and documents sent with it under section 173, and making such examination, if any, of the accused as the magistrate thinks necessary, and after giving the prosecution and the accused an opportunity of being heard, the magistrate considers the charge against the accused to be groundless, he shall discharge the accused and record his reasons for doing so. So in this section also we have to understand the very police report and the documents sent with that police report, जो सेक्शन 173 में एज अ चार्जशीट हम अंडरस्टैंड करते हैं। तो जब पुलिस रिपोर्ट के बेसिस पे वारंट केसेस मैजिस्ट्रेट चलाते हैं या फिर एक्यूज डिस्चार्ज हो सकता है या नहीं हो सकता है, इसको अगर इवेल्युएट करना है तो पहले ऑनरेबल मैजिस्ट्रेट को पुलिस रिपोर्ट को अंडरस्टैंड करना होगा और उसके साथ जो भी डॉक्यूमेंट्स है उनको वहाँ पे अंडरस्टैंड करना होगा। उसके साथ ही द ऑनरेबल मैजिस्ट्रेट शुड एग्जामाइन द एक्यूज एंड देन he must give the prosecution and the accused the opportunity of being heard, and then if he considers that the charge against the accused they are groundless, malicious, then in that circumstances the honorable magistrate can discharge the accused and he can record the reasons for doing so. So that is section 239, जिसमें पुलिस रिपोर्ट जो है वो वहाँ पे इम्पॉर्टेंट है। ऑन कंसिडरेशन ऑफ पुलिस रिपोर्ट डॉक्यूमेंट एंड अदर एग्जामिनेशन ऑफ द एक्यूज एंड द वेरी प्रोसिक्यूशन एंड द डिफेंस, प्रोसिक्यूशन एंड द एक्यूज, ये दोनों को सुनने के बाद अगर मैजिस्ट्रेट वहाँ पे कंक्लूड करते हैं कि एक्यूज़ को डिस्चार्ज करना चाहिए तो अंडर सेक्शन 239 एक्यूज़ डिस्चार्ज हो जाएगा। और तीसरे केस में जहाँ पे हम सेक्शन 245 को अंडरस्टैंड करते हैं, जिसमें जो वारंट केस मैजिस्ट्रेट के सामने चलते हैं अदरवाइज देन ऑन पुलिस रिपोर्ट, वो सेक्शन 245 ये भी डिस्चार्ज की बात करता है। तो इसमें सेक्शन 245 क्लॉज 1 जो है ये बोलता है, इफ अपॉन टेकिंग ऑल द एविडेंस रेफर्ड टू इन सेक्शन 244 द मैजिस्ट्रेट कंसिडर्स फॉर रीजन्स टू बी रिकॉर्डेड that no case against the accused has been made out which, if unrebuted, would warrant his conviction, the magistrate shall discharge him. तो यहाँ पे 245 ये जो सेक्शन है इसका रेफरेंस क्लॉज 1 में आया है। तो 245 में हम अंडरस्टैंड करते हैं that while discharging the accused, the magistrate has to take into account all the evidence which refer in section 244 of the Criminal Procedure Code. And in the warrant cases otherwise than on police report, section 244 बोलता है prosecution जो है warrant केस में जब कोई केस otherwise than on police report है तो वहाँ पे एक्यूज़ जब मैजिस्ट्रेट के सामने आता है तो वहाँ पे मैजिस्ट्रेट ने प्रोसिक्यूशन के सारे एविडेंसेस को अलॉन्ग विथ वॉट एवर सपोर्टिव डॉक्यूमेंट्स जो है उनको वो वहाँ पे पहले अकाउंट में लेना चाहिए। एंड देन क्लॉज 2 ऑफ सेक्शन 244 बोलता है, ऑन एप्लीकेशन ऑफ द प्रोसिक्यूशन court can issue a summons to any of its witnesses, directing him to attend or to produce any document or other thing before the court of law. And then after considering all the evidences, documents, and after considering the witnesses, as per clause 1 of section 245, मैजिस्ट्रेट अगर कंसिडर करता है कि देर इज़ नो केस मेड आउट अगेंस्ट द एक्यूज, एंड अगर इस केस को हमने रिबर्ट नहीं किया, देन द एक्यूज would warrant his conviction, and for that reason, in the interest of accused and in the interest of fairness of the procedure, the magistrate can discharge that particular accused. Clause 2 of section 245 provides that nothing in this section shall deem to prevent a magistrate from discharging the accused at any previous stage of the case if, for reasons to be recorded by such magistrate, he considers the charge to be groundless. अभी इस केस में जिसमें हम वारंट केसेस अदरवाइज दैन ऑन पुलिस रिपोर्ट की बात कर रहे हैं, इसमें मैजिस्ट्रेट जो है वो किसी भी प्रीवियस स्टेज पे ऑफ दैट पर्टिकुलर केस उस एक्यूज को डिस्चार्ज कर सकता है फॉर रीजन्स टू बी रिकॉर्डेड बाय सच मैजिस्ट्रेट दैट if the magistrate considers the charge to be groundless. And so ऐसी कोई भी चीज़ मैजिस्ट्रेट को प्रिवेंट नहीं कर सकती है at any previous stage of the case if magistrate have a concrete reasons to be recorded that the accused is charged without any grounds in that particular case. So that is a provision for discharge of the accused which provides under section 245 of the criminal procedure code. तो सेक्शन 227 में प्राइमा फेसी जो फैक्ट्स एंड सर्कमस्टेंसेस है, जो डॉक्यूमेंट्स है, उसके बेसिस पे विदाउट गोइंग इनटू द रोइंग एंड डिटेल इंक्वायरी एज टू द मेरिट्स एंड डीमेरिट्स ऑफ द केस बिफोर स्टार्टिंग विद द वेरी ट्रायल ऑफ द केस, अंडर सेक्शन 227 कोर्ट जो है दैट इज अ कोर्ट ऑफ सेशन can discharge that accused if the facts and circumstances on the face value does not discloses the existence of all the ingredients of the alleged offense against that particular accused. In section 239, in trial of warrant cases by magistrate instituted on the police report, under this provision also the accused can be discharged, provided the magistrate should consider first the police report, the documents submitted along with that police report under section 173, and on the basis of examination of the accused after hearing the prosecution and the accused, if magistrate considers that the charge against the accused is groundless, then under section 239 also the accused can be discharged. Then in the third case, that is trial of warrant cases instituted otherwise than on police report, in this we have to consider all the evidences submitted by the prosecution and on the basis of any witnesses, on the basis of the documents in support submitted by the prosecution, after taking into account all these particular evidences and material as per section 244 of the CRPC, अगर मैजिस्ट्रेट को लगता है कि there is no case against the accused, then in such particular case also the magistrate can exercise their discretion and can discharge the accused from that particular case. So this is the concept of discharge. We understand without conducting trial, the person or the accused can be discharged from any kind of imposition or any kind of criminal liability. Of course, that is not like acquittal. When we see the acquittal, then beyond the doubt of the honorable court, when it is proved that the accused is innocent, and to that effect the court pronounced the judgment, then that is something we understand as a acquittal. But when we say discharge, discharge is something for the time being we are taking out the very charges, what level against that particular accused, because those charges, those allegations, they are prima facie not made out against the accused. The ingredients of the offenses, they are not proved in the very face of that particular record of the case. And so at the discretion of the judge, at the discretion of the court, the honorable court may discharge that accused from that particular criminal liability. But in future, if suppose any fact or evidence comes before the court with reference to that particular offense or the transaction, then in that case the person or the accused, against that person or accused, the charges can be framed. So this is all about the concept of discharge under or with reference to the provisions of criminal procedure code. You can refer the provisions of BNSS, which is a new law. So here we are stopping with this particular lecture. Thank you very much for watching this channel. Keep watching this channel. Thank you.